Self, 5 minutes, and we'll go through this. And Mr. Canaparo, you talked about something that I thought was very interesting, and that was trying to resolve the agency overcriminalization, where you said what we could do is put something forward where the agency would actually adduce the number of crimes that they have, determine what they actually have to have, and then, all the rest would be avoided. Can you expand on that?
Sure. I think that given the sheer number of such crimes that are on the books, that's probably the best way to proceed. If you ask them just to say, maybe through the Department of Justice, for instance, just say, give us the list of all the regulatory crimes, I fear that what would probably happen is that you would not get a list. It may actually be impossible. So what I think the better solution would be to do is to say to the agencies directly, all of you agencies that have any sort of criminal enforcement regulations or criminal enforcement authority, you must by a specific date give us the list of all of them. And any that you have which are not in that list are immediately voided. So that if the next year they tried to prosecute somebody with one of these arcane regs, that person could say, I have a defense. That has been voided by this statute. And I think that's probably the most efficient way to both count and cut at the same time. Because my fear is that if you just try to count, you won't actually ever get a number.
I don't disagree with that. Professor Turley, you said you wanted wall-in prosecutorial discretion because it seems to be a problem. And I would suggest to you that a blanket mens rea statute might do that. Do you have any other ideas on how to wall in the prosecution?
Well, we have two sets of criminal laws that we've been discussing. One is the most direct, which is in the criminal code for laws passed by Congress. And then we have this massive unknown body, really, of agency crimes that were basically written by the agencies. That's why we don't have really any walls. There are no walls. It basically is almost covers the same expanse as civil conduct. And you can't have a legal system like that, I think, without fundamental problems for citizens. So the idea is that prosecutorial discretion is supposed to exist within a walled space where you define that space, that this is the specific conduct, and you're absolutely right. If that space is defined by mens rea, then prosecutorial discretion really works quite well. And I want to say that I really am intrigued by Mr. Canaparo's idea that that you can ask the agencies, what are the crimes that you are enforcing, and just presume that everything that they don't mention is obviously a crime that's not that important to them. And we're going to have to engage in sort of categorical eliminations. You're talking about hundreds of thousands of crimes. So you're going to have to find some way to make deep and serious cuts. And the agencies can actually give you the map for that.
Thank you. Mr. Fox, while not explicitly mentioned in your written testimony, you've written about trial penalty in the past. Can you briefly explain why one of the problems we're talking about today, too many laws on the books, contributes to the perpetuation of the trial penalty?
Yeah, absolutely. Thank you, Mr. Chairman. So the trial penalty is the difference in the sentence that you're offered at a plea stage and what you would get post-trial. In theory, it should be the same, because if it's not the same, there's something changing there. And there's a number of ways that prosecutors can coerce people into pleading guilty. Someone before mentioned charge stacking, that's just filing multiple charges. They can threaten family members, threaten to re-indict as a habitual offender, use pretrial detention. When I was a public defender, I had clients who would be offered plea deals that they could walk home that very moment while the prosecutors were arguing that they were a danger to the community and needed to be held on bond if they were going to go to trial. Obviously, those two things cannot simultaneously be true, so that's another way that they frequently do that. They've even been able to threaten to impose the death penalty against people just to get them to plead guilty. And when you have things like mandatory minimums that tie judges' hands, so if they go to trial and are convicted, there's nothing the judge could do but impose the sentence that he or she is bound to impose. And then absent juries who are able to ask questions like, what would the sentence be if I convicted, or is this something that I think is appropriate as a member of the community to prosecute someone for? There's sort of, prosecutors have unbridled discretion. I will say, I also wrote recently, there's two federal judges, Judge John Kane in Colorado, Judge Jed Rakoff in New York, both of which Judge Rakoff actually said that the point reduction for accepting responsibility is unconstitutional, and Judge Kane said that he will not apply it for the same reason. And the argument basically is you're getting a reduction in sentence because you're pleading guilty. That undermines your Sixth Amendment right to a jury trial, and the right to a jury trial is the only right that exists twice in the Constitution. It's both in Article 3 and in the Sixth Amendment. So really, judges need to aggressively police plea bargains and not just blanketly, do whatever prosecutors ask them to do.
Thank you. Thanks for that. Thanks to our witnesses for being here today. It's kind of fun till the end, right? We appreciate you being here and your testimony, and we will adjourn this meeting.